Honorable Chief Justice, honorable members of the court, I'm Teki Somaudi. May it please the court.
Thank you, Mr. Maudi.
Honorable Chief Justice, I am G. Viren. I appear on behalf of the respondent.
Thank you, Mr. Van Vieren. This is the majority judgment that I have written, concurred in by Moseneke DCJ, Busielo AJ, Jafta J, Kampepe J, Madlanga J, Mdlandla J, Ngabinde J, and Zondo J. It concerns a restraining order granted in favor of AfriForum and Mr. City of Tshwane Metropolitan Municipality, hereinafter referred to either as council or city or municipality. The first two parties will for convenience be referred to as AfriForum. The council was ordered to stop removing the old street names in the Pretoria area and bring back those that had been removed already. One may wonder why the change of street names should be such a highly contested issue that a case relating to it had to travel all the way up to this court. The answer to that question, and for a proper understanding, to answer that question and for a proper understanding of the issues in this matter, a historical perspective and the implications of the underlying constitutional vision need to be outlined. The need to do so was accentuated by AfriForum's reliance on the preamble to the Constitution. South Africa is literally the last from the system that saw nothing wrong with institutionalized oppression of one racial group by another for no other reason but the color of their skin, shape of their nose, and the length or texture of their hair. The underlying reason advanced for this irrational differentiation was that African people in particular, and black people in general, were intellectually inferior, lazy, and lesser beings in every respect of consequence. As a result, there hardly was any city, town, street, or institution of note that bore a name that sought to give honor to black people's leaders or recognition to their institutions or treasured history. Everything about the oppressed was dismissively branded as backward and inconsequential. Virtually all recognition and honor was thus respectively given to and bestowed upon white history and their heroes and heroines. The system was all about the entrenchment of white inferiority and disadvantage. No wonder the United Nations resolved that that system was a crime against humanity. More than 3 centuries from the inception of that system, South Africans of all races took it upon themselves to create a platform for the normalization or harmonization of race relations, democratization of their country, and attainment of peace and social cohesion. Against all odds, the nation has admirably come to the point where impunified violence, racial hatred, or subjugation in all its manifestations is unlike before, seldom openly and proudly practiced. That said, colonialism or apartheid is a system so stubborn that its divisive and harmful effects continue to plague us and retard our progress as a nation more than 2 decades into our hard-earned constitutional democracy. Almost all cities, towns, and street names continue to reverberate with great sounds of veneration for the architects of apartheid, heroes and heroines of our oppressive and shameful colonial past. Virtually no progressive or potentially conciliatory change to city, town, or street names goes unchallenged. There are fairly regular challenges to the equitable distribution of honor to heroes of other cultural or racial groups, and a concomitant determination to preserve exclusivity to privilege and meaningful control. This highlights the crucial role of the preamble to our Constitution relied on by AfriForum. The preamble is, after all, a succinct expressionary statement that sets out the Constitution's purpose and underlying philosophy. By design, and like all others, our preamble captures the essential principles by which we, the people, seek to govern our affairs. It is such a crucial part of our Constitution that if only every citizen were to internalize it and live according to its terms, our aspirations would most likely be expeditiously realized. Knowing just how deep and engrafted the distrusts, divisions, and injustices were in the very being of some of our people from the days of apartheid, we have made a solemn undertaking to embark on an all-inclusive constitutional project geared at achieving national unity and reconciliation. The injustices of the past are not to be pampered or approached with great care or understanding or sympathy, and the immeasurable damage racism or cultural monopoly has caused requires that stringent measures be taken to undo it. That approach will help us move away from exclusivity to opportunities, racial domination and intolerance, to inclusivity, social cohesion, and equitable access to opportunities. The normalized demonization and stigmatization of heroes and heroines of our struggle for justice, peace, and freedom is now a thing of the past. We, the people of South Africa, promise to honor them, presumably the same way heroes and heroines have been venerated in this country and around the world. Just as important is the need to respect white and black South Africans who played a crucial role in building and developing South Africa into the modern country of note it now is. All of us must embrace and internalize the constitutional reality that this country belongs to all of us who live in it. Diversity thus ought to highlight the need for unity rather than reinforce the inclination to stand aloof and be separatist. An appreciation of the value addition or special contribution of diversity, as in other countries, should strengthen our collective resolve to unite and tap into the special skills and experiences of all diverse groups in this country for the betterment of all. As a people who were not only acutely divided, but were also at war with themselves, primarily on the basis of race, one of several self-imposed obligations is healing the divisions of the past. The effects of the system of racial, ethnic, and tribal stratification of the past must thus be destroyed and buried permanently. But the healing process will not even begin until we all make an effort to connect with the profound benefits of change. We also need to take steps to breathe life into the underlying philosophy and constitutional vision we have crafted for our collective good and for the good of posterity. That would be achieved partly by removing from our cities, towns, dorpies, streets, parks, game reserves, and institutions names that exalt elements of our past that cause grief to other racial groups or reopen their supposedly healing wounds. Also, by removing even some innocuous names that give recognition only to the history, language, culture, or people of one race, so as to make way for the heritage and deserving heroes and heroines of the previously excluded. This is to be done sensitively and in pursuit of inclusivity, unity in diversity, and recognition of the need for a sense of belonging for all. We all have the duty to transform our society rather than bend over backwards to make racial tendencies feel comfortable and seem dignified. and all black and white are an essential part of we, the people of South Africa, that shoulder the burden to do so. Our shared values that underpin our constitutional vision cannot be achieved when one race almost always has its way or has the near absolute monopoly of respect and honor. That is a recipe for the illegitimate retention of exclusive privilege, undeserved domination of the past, and future hostilities as opposed to inclusivity, reconciliation, and unity in diversity we have undertaken to pursue and achieve. No measure of sophistry, contortion, or strategy ought to be allowed to entrench any form of racial domination or exclusivity to privilege, honor, and opportunities, for that is inconsistent with our foundational values and constitutional vision. South Africans of all races must unite to secure a brighter, peaceful, stable, and prosperous tomorrow by allowing the previously excluded groups to also be honored in their own land. They too should at long last have a sense of belonging. This case highlights the need to familiarize ourselves with our vision in the preamble to our Constitution. It also sounds a clarion call to South Africans of all races to take to heart the foundational values of our Constitution, like human dignity, equality, the advancement of human rights and freedoms, non-racialism, and non-sexism. When our actions are informed and driven by these facets of our constitutional project, then a proposed change of names of landmarks, streets, and institutions would only attract constitutionally inspired and constructive opposition. Strife and the consequential deepening of the divisions of the past would thus be most likely avoided or minimized. All peace and reconciliation-loving South Africans whose worldview is inspired by our constitutional vision must embrace the African philosophy of Ubuntu. Mutu ke mutu ka batho ba bangwe, or umuntu ngumuntu ngabantu. Literally translated, it means a person is a person because of others. The African world outlook that one only becomes complete when others are appreciated, accommodated, and respected must also enjoy prominence in our approach and attitudes to all matters of importance in this country, including name changing. White South Africans must enjoy a sense of belonging. But unlike before, that cannot and should never again be allowed to override all other people's interests. South Africa no longer belongs, in quotes, to white people only. It belongs to all of us who live in it, united in our diversity. Any indirect or even inadvertent display of an attitude of racial intolerance, racial marginalization, and insensitivity by white or black people must be resoundingly rejected by all South Africans in line with the preamble and our values if our constitutional aspirations are to be realized. South Africa still looks very much like Europe away from Europe. A very insignificant number of names of our cities, towns, and streets gives recognition to the indigenous people of this country and other black people. Very little recognition or honor is given to their heritage, history, heroes and heroines in their own motherland. This does not reflect, but rather belies a commitment by all to the spirit of genuine unity, transformation, and reconciliation. In this country, names of places and institutions of importance generally celebrate one-sidedness and at times resonate with the legacy of our oppressive past with unbelievable boldness and alacrity. Hopefully, this does not signify a disinclination to change for fear of protestations by the retentionists that the mere change of what they cherish, however minuscule, not only poses a threat to them and their environment, but also denies them a sense of belonging. For that position would inadvertently be saying to those who are victims of colonialism and apartheid that they have no legitimate claim to any sense of belonging whatsoever. Our constitutional vision militates against a never-ending determination to oppose change to city, town, or street names. Through the preamble and the entire Constitution, we imposed on ourselves the duty to transform. Recognition of the injustices of the past is neither a slogan nor an empty or meaningless assertion of recognition. It heralds an obligation to actively participate, not in the perpetuation, but in the eradication of the injustices of the past. Honoring those who suffered for justice and freedom, like Dr. Beyers Nodier and Advocate Brown Fisher, promises, among other things, the naming of streets and institutions of importance after them. Respecting those who worked and developed South Africa recognizes the role of our black and white compatriots who toiled over the years to make our country better than it was before. For indeed, South Africans across racial lines worked hard to change the country for the better, even during apartheid. A belief that South Africa belongs to all who live in it, united in our diversity, is the antithesis of any obsession with or exaggeration of the role and importance of one racial group above all others. Thoroughgoing introspection is thus called for. Both black and white South Africans need to strive for the attainment of our shared values and constitutional aspirations. It is impermissible to ever adopt an attitude that seems to suggest that some of our people can afford to endure the pain and torture induced and symbolized by instruments of the colonial and apartheid legacy, probably because they have enjoyed them long enough to find them tolerable, if not somewhat acceptable. This is even more so where others are categorical about their total inability to tolerate progressive and inclusive instruments like streets bearing names of leaders from other cultural groups, even temporarily. Nothing that objectively encourages or seeks to perpetuate the stereotypes, prejudice, or discriminatory practices of the past is to be tolerated. Inclusivity, unity in diversity, recognition of the culture and history of white and black South Africans, and reconciliation are our chosen paths to the prosperous future. They accelerate social cohesion and the process of healing the divisions of the past. This national project demands that we reject everything that sustained, entrenched, and still promotes racial discrimination. Ours is a country with great potential for enduring peace, stability, and sustainable economic growth. Much will, however, depend on how we manage our differences as individuals, groups, and as a nation. Our utterances and actions must always take cue from the foundational values of and preamble to our Constitution. Our commitment to reject the injustices of the past, the disunity and pain they brought upon us, must be unwavering and matched by our actions. That way, and in harmony, we will be able to replace old names that celebrate people and things that divided and cost us deep and incalculable pain, with new ones that recognize the previously ignored and unify the nation. Our peculiarity as a nation impels us to remember always that our Constitution and law could never have been meant to facilitate the frustration of real justice and equity through technicalities. The kind of justice that our constitutional dispensation holds out to all our people is substantive justice. This is the kind that does not ignore the overall constitutional vision, the challenges that cry out for a just and equitable solution in particular circumstances, and the context within which the issues arose and are steeped. We cannot emphasize enough that form should never be allowed to triumph over substance. Our Constitution was never meant to be a selectively recognized weapon, conveniently produced and used by some of us only when it could help advance illegitimate sectarian interests through legal stratagems. It was designed to facilitate justice and equity for all. That said, legitimate individual or sectarian rights and interests may always be vindicated and appropriately addressed within the prism of this constitutional dispensation. This should therefore not be misunderstood to mean that the end will always justify the means. This then sets the scene for the resolution of a challenge to the order that seeks to preserve street names that Council believes are irreconcilable with our constitutional project. Council took a decision to change 25 of the many street names in Pretoria and the surrounding areas. It in effect says that this change was necessitated by the dictates of inclusivity, unity in diversity, overdue recognition of and bestowal of honor to the previously dishonored, as well as the need to heal the divisions of our past. AfriForum has consistently opposed the mooted changes from the beginning all the way through to the implementation of Council's resolution to replace old street names like Dr. Hendrik Verwoerd, Louis Botha, and Walker with new ones like President Nelson Mandela, Chief Justice Ismail Mohammed, Solomon Mahlangu, and Steve Biko. Having passed the resolution to change some of the names arguably linked to the colonial and apartheid legacy, Council embarked on the process of implementing its resolution. AfriForum saw it as an assault on the treasured history and heritage of the Afrikaner people, which could not be left unchallenged. As a result, they launched an urgent application for an order restraining Council from removing the old names and directing it to restore those names that had already been removed. The order was granted by Prinsloo J in those terms, pending the finalization of the review proceedings. The rationale behind the grant of the interim order is essentially this. The old street names are an historical treasure and a heritage so intimate to the very being of the Afrikaner people that their removal would constitute an infringement of their right to enjoy their culture as an institution. So dear and invaluable are the old street names to them that even their temporary displacement would not only give rise to inestimable emotional hurt, but also to irreparable harm. The replacement of old street names with those of black people would, according to AfriForum, somehow toxify the environment to the point of jeopardizing the health of like-minded residents of Pretoria. The temporary retention of the old names would, they say, give them a sense of place and a sense of belonging. Aggrieved by Prinsloo J's order, Council unsuccessfully sought leave to appeal against it. It then petitioned the Supreme Court of Appeal, which granted it leave to appeal to the full court. Jordan J, with Pretoria's J and Molefe J concurring, dismissed Council's appeal. An attempt was made to challenge that decision, but the Supreme Court of Appeal refused leave to appeal with costs, hence this application. Turning to leave to appeal, the Council's case is that AfriForum has not satisfied the requirements for the interim interdict they were granted. In particular, that it stood to suffer irreparable harm in the event of the interim order not being granted, and that the balance of convenience favors them. We hold that it was in line with Council's constitutional and statutory executive powers to govern the city of Pretoria and its surrounding areas, that it took a policy decision to replace the old street names with the new ones it considers appropriate to reflect our more inclusive dispensation. Implementation of that policy decision was underway when AfriForum applied for and obtained the interim order that stopped council debt in its tracks. Included in the implementation of the policy decision was the determination of the budget necessary to effect the change during the particular financial year. The effect of the order is not only to suspend and frustrate the implementation of that decision, but also to stretch the budget through, among other things, subsequent inflation and the rand's loss of value against major currencies. Now we know that to give effect to the order to bring back the old street names would, as at the time, have punched a 2.6 million rand hole in the council's budget. The common law test for appealability has since been denuded of its somewhat inflexible nature. Unsurprisingly so, because the common law is not on par with, but subservient to, the supreme law that prescribes the interests of justice as the only requirement to be met for the grant of leave to appeal to this court. Unlike before, appealability no longer depends largely on whether the interim order appealed against has final effect or is dispositive of a substantial portion of the relief claimed in the main application. All this is now subsumed under the constitutional interest of justice standard. The overarching role of interest of justice considerations has relativized the final effect of the order or the disposition of the substantial portion of what is pending before the review court in determining appealability. The principle was aptly set out in Outer by Museneke DCJ. What the role of interest of justice is in this kind of application again entails the need to ensure that form never trumps any approach that would advance the interest of justice. If appealability or the grant of leave to appeal would best serve the interest of justice, then the appeal should be proceeded with no matter what the pre-constitution common law impediments might suggest. This is especially so where, as in this case, the interim order should not have been granted in the first place by reason of a failure to meet the requirements for its grant. Where separation of powers is implicated and forbids the grant of the order sought to be appealed against, as in this case, the interest of justice demands that even an order that is not of final effect or does not dispose of a substantial portion of the issues in the main application nevertheless be appealable. Consequently, although the final effect of the interim order or the disposition of a substantial portion of the issues in the main application are not irrelevant to the determination of appealability and the grant of leave, they are, in terms of our constitutional jurisprudence, hardly ever determinative of appealability or leave. Operating with the ever-abiding consciousness of the crucial role separation of powers plays in our constitutional democracy, courts should thus be very slow to interfere with the legitimate exercise of constitutional or statutory powers, save in the clearest of cases or where bad faith or corruption or fraud was proved. Even the common law recognizes that courts should exercise the power to grant an interdict, restraining the exercise of statutory power, and I quote, only in exceptional circumstances and when a strong case is made out for relief, close quotes. This being a case that relates to a grant of such an interdict, it cannot be treated as an ordinary run-of-the-mill application for an interim interdict. It is about transformation and the related right to govern. Council's prospects of success are very strong, and this is, in terms of the decisions of this court, like informal traders, an important factor to be taken into account in considering appealability and leave to appeal against interim orders like this one. All of the above clamor not just for the conclusion that the order is appealable, but also that it is in the interest of justice that leave to appeal be granted to counsel. But there is more set out in this judgment, on the strength of which to demonstrate that the order of the full court is appealable and that leave should be granted. The additional basis for appealability is admirably dealt with by Jafta J in his strongly reasoned concurring judgment, which we endorse fully. To determine whether this is perhaps one of those cases where a proper and strong case or the clearest of cases has been made out for the interim relief, it is necessary to examine how AfriForum met the requirements for the grant of an interim interdict. Those requirements were, of course, set out in Sitlogelo and Webster as prima facie right that might be open to doubt, a reasonable apprehension of irreparable and imminent harm to the right if the interdict is not granted, the balance of convenience favorable to the grant of the interdict, and the absence of any other adequate remedy. AfriForum has said enough to meet the interdictory requirement of a prima facie right that is nevertheless open to some doubt. AfriForum, however, had to satisfy the High Court of its reasonably entertained belief that harm that is not too complex or mysterious to understand would befall them and others should the interim order not be granted. To this end, the sum total of their case is that the harm they are exposed to is the gradual loss of place or sense of belonging and association with the direct environment or living space, which is known to be of emotional value to people. AfriForum contends that the refusal to grant the interim order would cause them and like-minded people to suffer irreparable harm because of the strong emotional connection to the old names or loss of a sense of place and a sense of belonging that would flow from the removal of the old names. The sense of place and sense of belonging contended for by AfriForum is highly insensitive to the sense of belonging of other cultural or racial groups. It is divisive, somewhat selfish, and does not seem to have much regard for the centuries-old deprivation of a sense of place and a sense of belonging that black people have had to endure. On this logic, victims of the deleterious effect of colonialism and apartheid are entitled to orders directing the authorities to remove names that seem to perpetuate the colonial and apartheid legacy on the basis that they induce irreparable harm. As for the mind-boggling proposition by AfriForum that harm and toxicity would somehow come with looking only at the names linked to other racial groups, very little room, if any, seems to be left for the acceptance of black people as fellow human beings deserving of human dignity and equality, talk less of honoring them for their pursuit of justice and freedom in South Africa. It is very difficult to appreciate this kind of harm or apprehended environmental endangerment as deserving of legal protection. Whether AfriForum's preferred enjoyment of the cultural rights leaves room for other communities to enjoy their own and is therefore consistent with other provisions of the Bill of Rights is a question best left open for another day. AfriForum and its constituency do not have the right to have the old street names they treasure displayed in perpetuity. On the contrary, Council has the constitutional and statutory power to change them. The only right AfriForum, like all other residents, has is to participate meaningfully in a properly facilitated process leading up to the change of the street names. And old street names may still be reinstated if the outcome of the review proceedings be that the public participation process was not, for example, not only obligatory but also flawed in that it was not properly facilitated or was a sham. Additionally, if the cultural rights sought to be protected through the interim order would indeed be imperiled by the removal of the old street names pending the recommencement of the name-changing process, that temporary harm could be repaired by the reinstatement of those names if the review succeeds. So there is adequate alternative remedy available to AfriForum, even if it were not to be granted the interim interdict. AfriForum is required to establish that a balance of convenience favors the grant of the interim interdict. This requirement recognizes that in an application for a temporary restraining order, there will invariably be at least two competing interests, and those interests are inextricably linked to the harm a respondent is likely to suffer in the event of the order being granted and the harm likely to be suffered by an applicant if the relief sought is not granted. We now know that AfriForum and their discrete group fear that the refusal to grant an interim order would cause them emotional harm. This is because they consider the old names to be an integral part of their much treasured history and heritage. The removal of the old street names would deny them a sense of belonging and weaken their case on review. It must be said, though, that this must be counterbalanced against another reality of great historical and constitutional consequence, and that is that Pretoria is the capital city of South Africa. Pretoria does not belong only to the Afrikaners or white South Africans. It equally belongs to all of our people, white and black, united in their diversity. All racial groups in this country deserve to have their culture, heritage, history, heroes and heroines respected and honored by all. And street names that remain untouched in Pretoria and throughout the country overwhelmingly celebrate white history and their sense of belonging. The emotional harm that AfriForum relies on is thus grounded on a one-sided notion of a sense of belonging. The significance of a change of 25 old street names out of the many that lost their heritage must be taken into account. This is necessary because it also gives some sense of belonging to the previously disadvantaged South Africans, who are the overwhelming majority of the citizens of Pretoria and South Africa. Regard must be had to the fact that places like Pretoria were part of what was known as white South Africa during the apartheid era, and it is that legacy that is now sought to be tenaciously held onto with the aid of an interdict. Whatever harm AfriForum would suffer as a result of not granting the interim interdict would be significantly neutralized by an equally important sense of belonging of the previously disregarded. Public participation in any process is but one of the important aspects of the name-changing process that cannot be legitimately ignored. The facilitation or genuineness of any public participation process is of course subject to judicial scrutiny. The propriety of that process must, as is the case with law-making public participation processes, be tested through a review process or similar proceedings based on the principle of legality. The same approach of confining the challenge to review proceedings should have been adopted here, regard being had to considerations of separation of powers. Instead, AfriForum seeks to stall the process of implementing a policy decision taken by Council that flows from the exercise of its constitutional and statutory executive powers. Public participation should not be elevated to co-governance or equal sharing of executive and budgetary responsibilities. Council bears the constitutional and statutory power to run the affairs of the city. For this reason, it cannot serve as the basis for a court to intrude into Council's sole operational space that a segment of those it serves is displeased with the public participation process Council had otherwise facilitated. The review process is the best avenue to vindicate whatever rights of AfriForum are implicated. Sight should never be lost of the fact that courts are not meant or empowered to shoulder all the governance responsibilities of the South African state. They are co-equal partners with two other arms of the state in the discharge of that constitutional mandate. Orders that have the effect of altogether derailing policy-laden and polycentric decisions of the other arms of the state should not be easily made. Comity among branches of government require extra vigilance against constitutionally forbidden encroachments into the operational enclosure of other arms. This is such a case. An interim interdict should, in these circumstances, be granted in the rarest of cases. Intrusion into the sphere of operation reserved only for the other arms of state is an exercise not to be unreflectingly or overzealously carried out by a court of law. It calls for deeper reflection and caution, especially where no case whatsoever was made out for the grant of an interim order, as in this case. An attitude that is dismissive of the constitutional firewall around the powers of other arms of state is not conducive to the proper observance of separation of powers and exhibits disregard for comity among the branches of government. In a dissenting judgment, Froneman J. and Cameron J. disagreed with the judgments written by me, first judgment, and Jafta J., third judgment. Their judgment started by appreciating that the wounds of colonialism, racism, and apartheid ran deep, and that the insensitivity to the continuing wounds by those who were not subject to those indignities could only exacerbate the fraughtness. However, they felt compelled to dissent for two broad reasons. The first was, I beg your pardon, the first was that the correction of the injustices of the past is not best served by attenuating well-established and sensible rules and principles for hearing appeals against the grant of temporary interdicts. Granting leave to appeal here extends existing doctrine considerably. This was not justified by the facts or the law. The municipality suffered no irreparable harm. The separation of powers was not breached, and it is not in the interest of justice to allow a dispute about a temporary order to drag on for more than 3 years, involving 19 judges, with the main review still undecided. The second reason was the implication that any reliance by South Africans on a cultural tradition founded in colonial history finds no recognition in the Constitution, because that history is inevitably rooted in oppression. The oppressive history is there, but the constitutional discontinuing of the cultural history many continue to treasure has momentous implications for a substantial portion of our population. It invited deeper analysis than it received here. There are many cultural, religious, or associational organizations that have roots in our divided and oppressive past. Are they all now constitutional outcasts merely because of a history tainted by bloodshed or racism? If that is what the Constitution demands, their judgment would wish to see a longer, gentler, and more accommodating debate than happened here. Their judgment doubts that the transformation of our society under the Constitution would be endangered if AfriForum were given space to pursue their objections. It may merely suggest the growing power of our democracy. For these reasons, they would have refused leave to appeal with costs. In a separate concurring judgment by Jafta J., I beg your pardon. In a separate concurrent judgment, Jafta J disagreed with a joint judgment of Cameron and Froneman JJ with regard to two of its pillars. Regarding the assertion that the Constitution should be read as recognizing racist cultural traditions of the past apartheid era, Jafta J holds that such an interpretation is untenable. He reasons that the Constitution establishes a clean break from the racist history characterized by discrimination, humiliation, and indignity to which black people were subjected. It emphatically rejects the disgraceful history and commits our nation to a democratic order in which all human beings are accorded equal dignity and respect, regardless of their race, color, creed, class, or gender. As to the argument that the order impugned by the City of Tshwane is not appealable, Jafta J disagrees with the joint judgment and advances a number of reasons for his opinion. First, he points out that the Supreme Court of Appeal had already granted leave to appeal against the interim interdict issued by Prince J. There was an appeal to the full court of the Gauteng Division of the High Court, which rendered a comprehensive judgment dismissing the appeal. Therefore, the City of Tshwane seeks to appeal against the order of the full court, which is not an interim interdict. Second, he shows that an appeal to this court is regulated by Section 167 of the Constitution and not the common law on which the joint judgment relies. He points out that in terms of Section 167, the test for granting leave is the interest of justice and not some common law requirements. He reasons that the relevant common law principles form part of what is considered in determining the interests of justice. Third, he demonstrates that even at common law, an interim order is appealable with the leave of the court of first instance. Therefore, it is incorrect to hold that interim orders are not appealable at common law. He concludes that he would have granted leave here even if the order sought to be appealed against was that granted by Prince J. Turning to the majority judgment, in conclusion, AfriForum failed to meet the requirement of irreparable harm, and the balance of convenience weighs heavily in favor of the dismissal of the application for an interim order. AfriForum's case is extremely weak. The interdict was granted and the appeal against it dismissed by the full court with little regard for AfriForum's duty to meet the requirements for an interim interdict and considerations of separations of power. Both Prince J and Jordan J were unable to explain satisfactorily how the requirements of irreparable harm and balance of convenience were met. The interim interdict should not have been granted in the first place, and the Supreme Court of Appeal should have granted leave to appeal. Instead, it dismissed the application with costs. In the result, the following order is made. 1, leave to appeal is granted. 2, the appeal is upheld. 3, the orders by Prince J and Jordan J of the Gauteng Division of the High Court, Pretoria, are set aside and the application for an interim interdict is dismissed. 4, the order of the Supreme Court of Appeal awarding costs against the Tshwane Metropolitan Municipality is set aside. 5, each party is to pay its own cost.
May it please the court.
As it pleases the court.
The court will adjourn.